Yes, good evening, all of you. All across the country, let us welcome people for the UPSC previous year question paper discussion. Today, I'll be discussing a few papers of UPSC. We'll stick to the subject of polity today. Okay, so I have brought the 2025, that's the recent paper, and the 2024 paper here. So let us start right away. So this is the first question that we have got. So let us read the question. With reference to the Indian polity, consider the following statements. An ordinance can amend any central act. So first question is related to the ordinance making power. So here, since it is central act, we'll assume that it is ordinance making power of the President of India. An ordinance can amend any central act. An ordinance can abridge a fundamental right. An ordinance can come into effect from a back date. So question, all the three statements are related to the ordinance making power. Ordinance, you know that it is like your executive law. The ordinance is proposed by the Council of Ministers, but it has been promulgated by the President himself. Okay. So bypassing the parliamentary procedures, they'll go ahead and make the ordinance in case there is a requirement, urgent requirement for the same. So let us analyze the first statement. The ordinance can amend any central act. So can the ordinance amend any central act? So ordinance making power of the President of India is basically subjected to the same limitations as an act of the Parliament and subject to the same conditions as the act of the Parliament. So ordinance can amend any central act? Yes. An ordinance can abridge a fundamental right. So can you actually abridge a fundamental right through an ordinance? Can the amendment being passed by the Parliament of India abridge a fundamental right? So answer is no, because of the basic structure doctrine. So in the Keshavananda Bharati case, what did the Supreme Court say? In the Keshavananda Bharati case, the Supreme Court said that the Parliament under Article 368 can amend any part of the Constitution, but not amend the basic structure. So fundamental rights are empowering in nature, and any attempt to disempower the citizens of this country by amending the fundamental rights or abridging the fundamental rights is not allowed. In case of ordinance also, we cannot abridge a fundamental right. So the second statement here that is given is wrong. An ordinance can come into effect from a back date. So if you are passing an ordinance today, can you make a law or an ordinance in such a way that it is coming into power from a back date? Yes, it is possible. Just like as I said, it is very similar to an act of Parliament. Can an act of Parliament be brought in from a back date? So it is possible for a civil law. There are two types of laws, civil law and criminal law. In case of a civil law, can we backdate the civil law? Yes. In case of a criminal law, can we backdate a criminal law? No. Why? Because Article number 20 says that no ex post facto criminal legislation or criminal law. That means a criminal law cannot be backdated. That's exactly what is the point here. So here what are they saying? That ordinance can come into effect from backdate? Yes, if it's a civilian law. Assuming that it's a civilian law, this is correct. So 1 and 3 here are correct. So we have the option C here. Okay. So are you all getting it? All of you? Yes. So for the first question, the answer is 1 and 3 only. Okay. So let us move on to the next question. Next question is, with reference to India, consider the following. So there were certain statements given here, or the councils, organization. First is the Interstate Council, the National Security Council, and the zonal councils. How many of the above were established as per the provisions of the Constitution of India? How many of them are mentioned in the Constitution is basically the question here. Okay. So the first one, Interstate Council, is it a constitutional body? Yes, because it is formed under the provisions of Article number 263 of the Constitution of India. We have the Interstate Council here. And National Security Council, is it a constitutional body? No. We have the National Security Council advising the Prime Minister of India. So current National Security Council is one of the strongest National Security Council that we have seen in the history of India. They advise the Prime Minister on the matters of security, on the matters of diplomacy, or we can say the international relations. Primarily looking at from the security point of view, but advising the Prime Minister even on the diplomatic front also. The National Security Council also has the National Security Advisor. Ajit Doval sir is the current National Security Advisor, acts as the secretary for this National Security Council. So when did we create the National Security Council? There was a need that was felt after the Kargil War. Kargil War happened in 1999 when Pakistan penetrated into Indian territory at Kargil, Ladakh. So after the Kargil War, the government felt that there were failures on multiple fronts. To address those security issues, they came up with the National Security Council and the National Security Advisor. These posts were actually created and organization of National Security Council. So they advise the Prime Minister today. So is it a constitutional body? No. Third one is the zonal councils. Now what are the zonal councils made up of? They are made up of, they are created mainly for coordination between states. So is it a constitutional body? No, it's a statutory body. They are formed under the Zonal Councils Act. Respective zonal councils have been created under the Zonal Councils Act. So what does the zonal councils actually consist of? It consists of the Home Minister of India. The Union Home Minister becomes the ex officio chairman of the zonal council. And who becomes the vice chairman? See, we have 5 zonal councils. The northern, southern, western, eastern, central, plus we have the northeastern council which also acts as a zonal council. Home Minister is the chairman and vice chairman is the CM of the state, and this post is held on the basis of rotation. That means if there are 4 states, all the 4 CMs will become the vice chairman of this zonal council through rotation. It will have CM plus 2 other ministers of the central government, of the state government. This is the composition of the zonal council. Why has this been made? To ensure that there is very good coordination between the center and the states. So if there are any state issues, example, if there are interstate water issues, interstate language issues, basically to uphold the unity and integrity of this country, to make sure that the divisive forces that are there, example, linguism, chauvinism, regionalism, secessionism, they should not lead to the break in the state of the country. That means it should not lead to partition. So we are all one. That is the intention behind zonal council. And if there are any like chota mota problems between different states, they should be able to solve them through negotiations. That is the basic funda behind zonal council. Now, is it a constitutional body? No. So how many of the above were established as per the provision of Constitution of India? Only 1. Are you all getting it? Clear, all of you? You need to start responding. Okay. Then next question. The Constitution of India explicitly mentions that in certain spheres, the governor of a state acts in his or her discretion. That means the governor of India has some discretionary powers. The statement says that the Constitution of India explicitly mentions, that means they are constitutional discretions. There are two types of discretions. One is the constitutional discretion, that is something that's written in the Constitution. And there is also something called a situational discretion, which is the governor and the president of India will get them in accordance with the situation. Those are called as the situational discretion powers. Now, what we are discussing here is the constitutional discretion powers only. The Constitution of India explicitly mentions that in certain spheres the governor acts in his or her own discretion. The President of India can, of his or her own, reserve a bill passed by the state legislature for his or her consideration without it being forwarded by the governor of the state concerned. So here the issue is, can the governor of the state concerned reserve a bill passed by the state legislative assembly to the President of India? Guys, you should tell me the answer. Can the governor of a state reserve a bill passed by state legislative assembly for the consideration of the President of India? So yes, it can be done under the article number 200. So here it is a discretionary power of the governor to do that. Now once he keeps it, the funda is in between your state legislative assembly and the President of India. But what does the statement say? The President of India can reserve on his or her own reserve a bill passed by the state legislature. That means bypassing the government, bypassing the governor, the President of India can take the bill passed by state legislative assembly without being forwarded by the governor of the state concerned. So can he do that? No. Any bill that goes to the President of India has to go through the governor only. He cannot take it directly because governor is considered as the constitutional head of the state. It's not the President of India. The President is not the head of the state here. That means the states like Karnataka, Tamil Nadu, etc. So here the second statement is wrong. The first statement says that the Constitution of India explicitly mentioned that in certain spheres the governor of a state acts in his or her own discretion. Yes, this is basically a comparison of your presidential and governor discretion. The President of India, as you know, that he does not have any constitutional discretionary powers. He has only situationary discretion powers. But with respect to the governor, he has certain constitutional discretion powers. What are the circumstances in which he has constitutional discretion powers? There are a lot of them here. So we can say that one, while reserving the bill for the president, as I told you, under the article number 200, he can reserve any bill for the consideration of the President of India if he feels that this bill endangers the Constitution of India or the security of the state or the federalism in India, or for any other reason he feels that the president has to look at this bill. So first one, yes, reservation of the bills passed by the Legislative Assembly to the President of India. The second one is recommendation of President's Rule, that is under article number 356. What does article 356 say? If there is a breakdown of constitution machinery, then the governor of the state can recommend to the central government or the President of India to enforce constitutional or state emergency. Now, the term breakdown of the constitution is not actually defined in the constitution. It has been subjected to a lot of different definitions by the Supreme Court of India as well as the other people, constitutional bodies. And what does article 355 say? 355 and 356 are linked to each other. 355 says that the central government has to make sure that the governance in the state is carried on in accordance with the principles of the Constitution of India and also protect the state against any internal or external disturbances or aggression. So in case of the governor, if he feels that there is a breakdown of constitutional machinery. That means the government of the state is carried not in accordance with the constitutional provisions, then he can send that recommendation to the President of India. Now, for that case, is he bound by the advice of the Council of Ministers? No. In general, is he bound by the Council of Ministers' advice? Yes. Both your President of India and the Governor both act as the head of the state, but they are all nominal heads. That is the reason they are bound by the advice of the Council of Ministers. So, Article number 74 and Article number 163 says about this. Then, additional charge as the administrator of a UT. So, can a governor of a state be concurrently made the administrator of a neighboring union territory? Yes, it can be. He can be the head of state in a state and he can be the administrator of a union territory. He can handle two responsibilities there. Now, for the state, he is bound by the aid and advice of the Council of Ministers. But with respect to the union territory, he is not bound by it. So, the State Council of Ministers cannot advise the governor about how he actually addresses the issues in the union territory. He is not bound by it. So, it is his constitutional discretion. Then, with respect to amount payable by the government of Assam, Meghalaya, Tripura and Mizoram, what are we talking about? We are talking about the 6th schedule of the Constitution of India. The 6th schedule of the Constitution of India is a promise made by the Constitution to the tribes of this country, especially the tribes from Assam, Meghalaya, Tripura and Mizoram, stating that we will not intervene in your tribal customs. We'll make sure that the governance of that state is carried on in accordance with the Constitution as well as the tribal culture that you guys have. We will in no way that will hurt your different needs or even rights or culture also. So that is a reason we have put the 6th schedule there. Under the 6th schedule, we have come up with what is called as autonomous district councils. So we are talking about that here. The autonomous tribal district councils which have been set up under this. So the amount needs to be given by the government to this autonomous district council in lieu of mineral exploration. You know that the tribal regions today are also the regions where we have a lot of minerals. These minerals, if they are extracted, so we have put a condition here saying that if a private company or a government company extract minerals from those places, whatever the money that accrues as profit, out of that pay some amount as royalty to the autonomous district council itself, so that the ADC can take care of any socio-economic needs of the tribals in that area. Okay, this is basically about the autonomous district councils. This is under the 6th schedule of the Constitution of India. Are you guys getting it? Okay, is it clear? Do I have to make it even more simple? When he calls upon the chief minister seeking for his advice. So likewise, the president can call upon the prime minister. The chief minister can call upon the governor of a state can call upon the chief minister and seek information related to any administrative or legislative affairs. So these are all the constitutional discretion powers of the governor. Now there are certain situation discretions also. Say for example, appointment of the chief minister when there is a hung assembly, dismissal of the council of ministers when they lost the majority in the lower house, etc. These are certain situational discretions and the constitutional discretion that the governor of the state has got. So it's a very simple topic, but the UPSC has asked question about 6th schedule, the role of the governor, the role of the president, their discretionary powers, etc. repeatedly. So discretionary power of the president, discretionary power of the speaker, discretionary power of the vice president, discretionary power of the governor, these are all constitutional authorities. Their discretionary powers are very, very important theme for your UPSC preparation. Okay, so mark that. Okay, I have explained discretionary powers of the governor. Now it is your duty to go ahead and read the discretionary powers of the President of India, as well as other constitutional bodies like your Speaker, Deputy Speaker, Vice President, etc. Okay. So this is the question number 3. Now, the question number 4. Consider the following pairs. Provision in the Constitution of India stated under separation of judiciary from the executive in the public services of the state is a part of DPSP. Valuing and preserving the rich heritage of our composite culture is a part of fundamental duty. Prohibition of employment of children below the age of 14 years in the factories is a part of fundamental rights. So the first part says that these are the things which are in the Constitution, and in which part are they? First one, separation of judiciary from the executive in the public services of the state. Is it part of your DPSP? Yes, it's part of your DPSP. It's part of your Article 50. So we always wanted to distribute the power. So to prevent any concentration of powers in the country, the constitutional powers of judiciary and constitutional powers of the executive should be separated from each other. That is an ideal. This is your Article number 50. Have we separated everywhere? Wherever possible, we have separated it. But yes, certain executive powers have been given to the judiciary also, and certain judicial powers have been given to the executive also. I'll discuss all these things in the future classes. Okay. Valuing and preserving of the rich heritage of our composite culture, is it part of fundamental duty? Yes, obviously it is part of your fundamental duty. Prohibition of employment of children below the age of 14 years in the factories, is it part of the fundamental rights? Yes. So prohibition of child labor, is it part of your Constitution? Yes. Right against exploitation. Okay. So how many of the above pairs are correctly matched? All the 3 are actually matched. Now, yes, we have the option C here. All the 3 are actually correctly matched. Okay. You guys are getting it? Clear? Fine. Shall we move ahead? Yeah. The next question. Consider following statements with reference to the Constitution of India. If an area in a state is declared as a scheduled area, as I told you, 5th schedule and 6th schedule are some of the favorite topics for UPSC. We have been seeing repeated questions on 5th and 6th schedule from the last 10 years. Okay. So with respect to Constitution of India, if an area in a state is declared as a scheduled area under 5th schedule, the state government loses its executive power in such areas and a local body assumes total administration. Union government can take over the total administration of such areas under certain circumstances on the recommendation of the governor. Which of the following statements given above are correct? So you need to look at this thing also, because they may ask incorrect or correct. A lot of students do not read the question completely. In a certain tension or say nervousness, ho jata hai mistake. So we all do make mistakes, but please look at this thing. Okay. So they're asking for the correct statement. So let us analyze the statements now. This is regarding a scheduled area, 5th schedule. 5th schedule means article number 244, subclause 1. The state government loses its executive power in such areas. Is it true? No. What does the first statement in the Article 244 say? That the state government has executive power over these areas and it is not with respect to the local body. So it is wrong. Union government can take over the total administration of such areas under certain circumstances of the recommendation of the governor. Can they do? No. See, why are the 5th schedule areas being given? See, 5th schedule comes under Article 244. 5th schedule is basically about the 10 states where they are declared as scheduled areas and tribal areas. So these are the areas which consist of tribal people and are highly underdeveloped. So to make sure that these regions develop, we have given the 5th schedule there. So which all states are covered under this 5th schedule is a very important topic also. That has also been asked in the UPSC previously. So we have Rajasthan, we have Himachal Pradesh, we have Gujarat, Madhya Pradesh, Chhattisgarh, Jharkhand, Odisha, West Bengal, we have Maharashtra, we have Andhra, and we have Telangana. So how many? 3, 6, 3, 6, 9, 10. Not West Bengal. Okay, sorry. So 10 states here. So 10 states have been given powers under the fifth schedule. So what does the fifth schedule say? Fifth schedule says that you need to come up with what is called as a tribal advisory council. What does a tribal advisory council consist of? It consists of 20 members. Out of these 20 members, 3/4 of these members have to be the MLAs of the state legislative assembly, respective state legislative assembly, and they need to be MLAs of the state legislative assembly. Okay. So rest of the people can be nominated. So likewise, these MLAs, they advise the government on how the economic and social development of these people in these areas can be made. That is basically what is called as a tribal advisory council. Now, who declares an area as a scheduled area? It is the President of India. The President of India, in consultation with the governor of a state, can declare any area as a scheduled area in the state. He can decrease the area, he can increase the area, he can change the borders of the area, etc. So the President enjoys certain powers with respect to the scheduled areas in the state. Okay, this is basically what is the fifth schedule of the Constitution of India. Now both the statements are wrong. They are asking for correct statement. So neither 1 nor 2 is the answer. Okay, are you guys getting it? So questions, have they become tougher? Questions, have they become tougher? No. We have seen good quality questions, very similar quality questions in the previous question papers also. So difficulty level wise, they have not changed much with respect to polity. More or less, they have stuck to the same thing. Okay. Let us analyze the next question. Consider the following subjects under the Constitution of India. List 1, Union List in the 7th schedule. Extent of executive power of the state, conditions of the governor's office. For a constitutional amendment with respect to which of the above, ratification by the legislatures of not less than 1/2 of the state is required before we present it for the presidential assent. So this question is about article number 368. Another very favorite topic for UPSC, article 368. Article 368 is about the constituent power of the parliament. Now there have been a lot of questions on the constituent power of the parliament even previously also. Which part of the constitution can the parliament amend? What are the limitations on that, etc. So article 368 says that if you want to amend the constitution, you would require a special majority. Article 368 clause 1 says that if the parliament wants to amend the constitution, then they need a special majority. Second, the article 368 also says that if they are amending any federal provisions, if they are amending any federal provisions का मतलब क्या है? Federal provisions का मतलब है if the states are also interested in that matter. मतलब अगर टैक्स है, एग्जाम्पल जीएसटी का, सो अगर सर्विस टैक्स है तो इवन स्टेट्स आर गोइंग टू बी इंटरेस्टेड इन दैट. सो इट्स नॉट जस्ट द सेंट्रल गवर्नमेंट का एक का डिसीजन नहीं है. Central government and state government both need to sit together and take decision. So these are what's called as federal provisions. So if the federal provisions have to be changed, then they require a special majority plus ratification by more than half of the state legislatures. They require ratification by more than half of the state legislature. आधे से ज्यादा राज्यों का अनुमोदन चाहिए, more than 50% of the state legislature. Likewise, if you understand this, they are saying that consider the following subjects in the constitution. For a constitution amendment, which of the above ratification by legislatures of not less than 1/2 of the states is required before the presenting it. That means they are asking for Article 368 Clause 2. Now, one by one, list 1, union list in the 7th schedule. Any list, and union list, this 7th schedule has 3 lists. It has union list, it has state list, and it has concurrent list. So what is union list? These are the list of items on which the parliament makes the law. State list, items on which state legislature can make the law. Concurrent list, both parliament and state legislature can make the law. And any changes that has been brought in to this list, any changes with regarding any list, it falls under the article number 368(2). So this one, yes, it is correct. You need to know very clearly which of them require 368(1), which of them require 368(2). For UPSC student, this topic is very important. Then second one, extent of the executive power of a state. So if you want to change the extent of executive power of the state, now does the state has executive power? Yes, because we have a federal polity. We have something called as federalism in our country, where the power gets divided between the union government and the state government. This is called as the vertical devolution of the powers. So on the top you have the central government, in between you have the state government, and below we have the local government. So power gets shared. Now this power sharing between them, is it constitutional? Yes, constitutional sharing of powers is there now. And with respect to extent of executive power, if you want to change anything with respect to this, yes, it is under the Article 368 Clause 2. Then conditions of the governor's office. So governor's office का condition change करने के लिए 368 सब clause 2 का amendment नहीं बोला जाता, 368 सब clause 1 का amendment बोला जाता है. मतलब you don't require the ratification of more than half of the state. You require special majority only. Okay, ठीक है. So this is, are they asking for correct? Yes, they are asking for correct one. So 1 and 2. 1 and 2 only. Okay, so this is the 6th question under the UPSC paper 2025. Now 7th question, generally 12 to 15 questions will come from polity every year. With reference to Indian polity, consider the following statements. The governor of a state is not answerable to any court for the exercise and performance of powers and duties of his or her office. Now again we have come back to the governor of the state. So governor के बारे में बहुत ही obsession है UPSC को. So schedule 5, schedule 6 and governor are their favorite topics. Okay. So again they have come back to governor. The governor of a state is not answerable to any court for the exercise and performance of the powers and duties of his office. Yes, because the governor and president are also constitutional bodies, and definitely they are not answerable to the court. Second, no criminal proceedings shall be instituted or continued against the governor during his or her term of office. So article number 361, the immunity that has been provided to the governor and the president of India. For certain constitutional functionaries, the constitution itself provides certain immunity. One of the immunity is there should be no criminal prosecution against a sitting governor or the president while they are in office. So criminal prosecution cannot be instituted. Sir, can we put a civil case against that person? मतलब पर्सनली कुछ कर दिया उसने तो सिविल केस भी नहीं डाल सकते क्या? ऐसा कुछ नहीं है, सिविल केस डाल सकते हैं, but there has to be a 2-month notice that has to be served to the governor and the president. Only after that you can actually institute a civil case. So why institute at all? At least choose people who do not do anything like this. Let us choose people who do not get into any problems either criminally or civil wise. That means they should not get into conflict with law. So Civil and criminal case mein, they cannot be instituted. Yes. Members of a state legislature are not liable to any proceedings in any court in respect to anything said within the house. These are part of the privileges of the members of the house. Another very, very hot topic, important topic, evergreen topic for UPSC. They've been asking about the privileges of the MLAs, the MPs every now and then. Okay, so here they've combined it with the other things also. The member of the state legislature, the MLAs, whatever they say and do on the floor of the house, it is not questionable in the court of law. Yes, that is not questionable in the court of law. That is one of the privilege that is given to these guys. So all three statements are correct. They're asking for which of the following are correct. So 1, 2 and 3. Are you guys getting it? These are the first 7 questions. Next. Consider the following statements with regard to the pardoning power of the President of India. They are also called as the clemency powers of the President of India. The exercise of this power by the President can be subjected to limited judicial review. So it has been a very, very controversial statement. That means if you are the President of India and if you are exercising certain clemency powers, is it subjected to judicial review? So the Supreme Court has said that yes, it is subjected to judicial review, but the judicial review is limited. Now, what is basically the clemency? Clemency is basically if the person feels like whatever sentence that is given by the Supreme Court of India is not correct, then he can actually apply for a clemency or a pardon petition to the President of India to leave the room open for any mistakes that could have been done by the Supreme Court of India. We have the clemency powers. Now, can the President also make mistakes in that? Yes. What is limited judicial review? The Supreme Court of India can check if there is a malified intention on the part of the President of India. That means he has taken this decision regarding the clemency in very bad faith. That is what is called as malified. So if there is a bad faith decision, then yes, it is subject to judicial review. Limited, yes, not completely. Second, President can exercise this power without the advice of the central government. No. So when it comes to the clemency petition, even though the decision appears to be taken by the central government, appears to be taken by the President of India, but it is not his discretionary. That means he is not the person who is actually going through that case and deciding whether that person is culprit or not. It is actually the Union Home Ministry which goes through that case and decides whether that is a fit case for providing clemency to the person. So Union Home Ministry recommends it to the Cabinet recommends it to the President of India. So here also he is bound by the aid and advice of the Council of Ministers, and it is not the discretion power of the President. So the second statement is wrong, the first statement is right. So which of the following statement given are correct? So one only is correct. Okay. So governor getting repeated, discretionary powers getting repeated. Judicial review, again very favorite topic for them. Ninth question. Consider the following statements. On the dissolution of the House of the People, on the dissolution of the House of the People, the Speaker shall not vacate his or her office until immediately before the first meeting of the House of the People after the dissolution. Now the statements are about the Speaker. When does he vacate his seat? So let us analyze the first statement. on the dissolution of the House of the People, the Speaker shall not vacate his or her office until immediately before the first meeting of the House of the People after the dissolution. Yes, the lifetime of the Lok Sabha is 5 years. So once there is completion of 5 years, it is subjected to automatic dissolution. Once there is automatic dissolution, all the members of the parliament will lose their seat, but the Speaker of the House will not lose his seat. He will still be called as the Speaker, or he remains in the Speaker's position till there is a first meeting of the House of the People. Now, is it correct? Yes. Second, according to the provisions of the Constitution of India, a member of the House of the People, on being elected as a Speaker, shall resign from his or her political party immediately. That means आपको, अगर आप MP हैं, आपको स्पीकर बना दिया, आपको स्पीकर बनाने के बाद आपका पार्टी का जो एडमिशन है वो स्पीकर रिजाइन करेगा क्या? Will you resign from the party or not? So no. The person will stop associating himself with the party more, no doubt about it. But does he have to resign from the party? No. Is it a constitutional requirement to resign? No. Is there a parliamentary convention to resign? No. Sir, then why did the question come into picture? Because Britain में होता है. Because we have taken all this from the UK. लोग बोलते हैं अगर यूके में आप स्पीकर हो जाओगे तो आप पार्टी को रेजिग्नेशन दे दो. Once you are stepped down from being a speaker, you can go back to being the party member. Now, why is that done? Because speaker has a lot of powers, and those powers should be exercised in a unbiased manner. That means you should not be partial. You need to be impartial towards the opposition party as well as your own party. So you are no longer a party member, you are a constitutional functionary. Now that is a very responsible position. Now that responsible position, does it require resignation in UK? Yes. Does it require resignation in India? No. So statement 2 is wrong. Statement number 3. The Speaker of the House of the People may be removed from his or her office by a resolution of the House of the People passed by majority of all the then members of the House. That means if you want to remove a speaker, the Lok Sabha has to pass a removal resolution with a effective majority. The Lok Sabha has to pass the resolution with a effective majority. When they say then members of the House, it is absolute majority minus the vacancy, provided that no resolution shall be moved unless at least 14 days notice has been given to the intention to move the resolution. Yes, this statement is correct. 14 days notice needs to be given to the speaker, and the Lok Sabha has to pass the resolution with a effective majority. So statement number 3 here is correct. So statement number 1 and statement number 3 both are correct. They are asking for correct statement. So 1 and 3, that is C. C is the correct answer here. So are you guys getting? The questions have been simple. The questions have been picked from those areas which are considered as hot topics. A lot of them have been in news of late, that is last 3 to 4 years. And wherever there are certain inconveniences, discretionary pass and other things, etc., that is exactly where the questions have been raised. Because people had always a problem to understand what is effective majority in the Lok Sabha. So they have come up with a question here. So C, 1 and 3 only. Then 10th question. Consider the following statements. If any question arises as to whether a member of the House of the People has become subject to disqualification under the 10th schedule, the President's decision in accordance with the opinion of the Council of Union of Ministers shall be final. Again, UPSC is also quite obsessed with parliamentarians and your MLAs, their privileges, their powers, their discretions, etc. So we saw one question previously asking whether their conduct in the parliament or the state legislature is under the judicial scrutiny. No. Now what they are asking is under the 10th schedule, that is the anti-defection law. So to prevent people from jumping across parties and horse trading, so we brought in the anti-defection law through the 52nd Constitutional Amendment Act 1985. And under this anti-defection law, what have they said this? If say for example, somebody has as a member of parliament, you have violated the whip of the party. What are the, I'm explaining what are the circumstances under which you can be, say, considered as a defector. That means you lose the seat, your seat in the house. If that MP has violated the whip, then he can lose his seat. If he resigns voluntarily, that means he gives up the seat of the house or party membership voluntarily and joins the party after winning the election. He has won the election. Now voluntarily he is giving up the party membership. He is trying to join another party. Can he do it? Yes, but he has to resign the seat because he has won it on the symbol of that party. Then if an independent member becomes a member of a party. So once you are elected as an independent member, you need to stay as an independent member. Now, after being elected as an independent member, if you go join a party, then yes, your seat is going to become vacant. Then, if there is a nominated member, you understand that there are nominated members in the house also. So, there are 12 members who have been nominated to the Rajya Sabha. There are 6 months time allotted to these guys to join any party of their choice. If the nominated member want to express thanks to the party that has nominated him or her, they can actually go join that party itself. So, but they need to do it within 6 months of the nomination. If they do it after 6 months, yes, that is also considered as a violation of the anti-defection law. So, under this, who takes the call whether the defection has taken place or not? The call is taken by the Speaker of the House. The call is taken by the Speaker of the House. So, here, who is taking the call? The President on the advice of the Council of Ministers. Now, is it a correct statement? No, it's a wrong statement. Second, there is no mention of the word political party in the Constitution of India. So, is the term political party not mentioned? It is mentioned. Sir, where is it mentioned? It is mentioned in the anti-defection law itself. So, the term political party is mentioned in the anti-defection law. So, hence we cannot say that it's not there in the Constitution of India. So, which of the statements are correct? So, 1 and 2, both are wrong. So, it is neither 1 nor 2. Are you able to understand? Okay, that's great. Okay, hope the class is going well. Okay, is it interesting? Yes, stay with me. Next question, statement 1. In India, state governments have no power for making rules for grant of concessions in respect of extraction of minor minerals, even though such minerals are located in their territories. Now here, it is about the executive power and the legislative powers of the central and the state. In India, state governments have no power for making rules for grant of concession in respect of extraction of minor minerals. So, in India, we classify minerals into two types. One is the minor minerals, other is the major mineral. Now, minor mineral come under the state governments. So, they say that there is no power with respect to state government. The statement is wrong. Second, Statement 2, in India, the central government has the power to notify minor minerals and other relevant law. Now, who will say that XYZ mineral is a minor mineral in the country? It is notified by the central government itself. So, hagagi, the statement 2 that is there here is correct. They are asking for which of the following are correct. So, statement 1 is wrong and statement 2 is correct. So, D will be the answer. Statement 1 is not correct, but statement 2 is correct. Then 12th question, it is related to the panchayats. Panchayats at the intermediate level exist in all the states. So you need to be very careful about this word called as all here. Generally speaking, any extreme statement like this, all, none, etc., they cannot be trusted easily, right? So we have, trust issues with these guys. So they cannot be trusted easily. So there is always a question mark, right? So here, when they say intermediate level, जो है पंचायत का, it exists in all the states. So it cannot be, because you need not constitute an intermediate panchayats if your population of the state itself is less than 20 lakhs. Example is your Sikkim, 6 lakh का population है. आप ग्राम पंचायत बनाओगे, आप इंटरमीडिएट पंचायत बनाओगे, आप जिला पंचायत भी बनाओगे. So almost everybody will become the members of that. So population जब इतना छोटा है तो 3 लेवल पे पंचायत करना नामुमकिन है, and it is not required also. So the constitution has given a exemption to these guys, saying that अगर आपका population 20 लाख के नीचे है तो आप इंटरमीडिएट पे आपको पंचायत बनना जरूरी नहीं है. Next, to be eligible to be a member of the panchayat at the intermediate level, a person should attain the age of 30 years. To be eligible to be a member of the panchayat at the intermediate level, a person should attain the age of 30 years. Is it true? To become a member of panchayat, what does your article 243 say? It says that बंदा को 21 years होना चाहिए. तो आप पंचायत का मेंबर बन सकते हैं, इलेक्शन में खड़ा हो सकते, ट्राई कर दीजिए. 21 years है. So if you want to become the member of the Legislative Assembly or the Lok Sabha, it is 25. If you want to become the governor or the president, it is 35. So age आपको दिमाग में रखना होगा. So is it 30 years? No, it is 21. In all the states, no, it is wrong. So first statement, second statement दोनों wrong है. Chief Minister of a state constitutes a commission to review the financial position of the panchayats at the intermediate levels and to make recommendations regarding the distribution of net proceeds of taxes and duties leviable by the state between the state panchayats in the intermediate level. Now here they are actually talking about the State Finance Commission. So State Finance Commission क्या होता है? See, in the country, because there is federalism, मतलब there has to be federalism on the financial front also. उसको हम लोग fiscal federalism बोलते हैं. So fiscal federalism का क्या मतलब है? We have the government of India and we have the government of state. The government of state, they contribute to the revenue. Now that revenue from all the state goes into the pool. Now this pool has to be divided between the government of India and the government of state and in between the state also. So if you allow the central government to actually start giving resources to the state as per their wish, अगर उनका पॉलिटिकल पार्टी है तो ज़्यादा दे देंगे, अगर अपोजिशन का पॉलिटिकल पार्टी पावर में है स्टेट तो कम देंगे. So it is penalizing the people of that state for choosing a government which is different, which belongs to a different party compared to that of the union government. Now that is not democracy. So that is why we have Article 280. Article 280 के अंदर Finance Commission आता है. The President of India forms the Finance Commission every 5 years. What does the Finance Commission do? Finance Commission will look at the net proceeds. So कितना आया? So इसमें state governments को कितना देना है? Now current Finance Commission says that 41% of the total revenue has to be shared with the states. बाकी आप रख सकते हैं 59%. So 41% of the revenue will go to the state. So net proceeds. Now why? Because this is a constitutional obligation now. We are creating constitutional obligation of the government of India to actually do it. ज़्यादा pressure डाल रहे. These are in the nature of recommendations. It's not compulsory on the part of the central government to do it. अगर वो करना चाहते हैं तो कर सकते हैं, मुमकिन है तो कर लो. Generally मुमकिन होता है, and since it's a constitutional body, the government of India also will take it seriously. Understood? So here what happens is we have got Article 280, that is a Finance Commission. Likewise, very similarly, Article 243I में State Finance Commission है. What does State Finance Commission do? अगर pool आ रहा है, state का pool आ रहा है, now this state pool need to be divided between the government of the state and the local bodies, because local bodies have also contributed to the pool and the amount has to go to them also. So in what ratio these needs to get divided? So it is done on the basis of the recommendation of the State Finance Commission. So it's also a constitutional body. So State Finance Commission, it will divide the resources. So local bodies के लिए बहुत सारे resources चाहिए होते हैं. So here, who constitute the State Finance Commission? It is constituted by the governor. It is not constituted by the CM as it is shown in the question. So question में क्या लिखा हुआ है? Question में ये लिखा हुआ है कि CM करते हैं. CM नहीं, it is the governor. And in how many years? Generally 5 years once. Okay, generally 5 years once. So Chief Minister of a state? No, it has to be the governor of a state. So this statement is also wrong. Okay, so which of the following statements are not correct बोल रहे हैं? That is why I asked you. Be very, very careful with this, because a lot of students come to us saying that अगर sir silly mistake हो गया, मुझे पता था, तो आंसर यही है, पर मार्क नहीं कर पाया, मार्क नहीं कर पाई. Why? Because they did not see this, saying that they are asking for correct or they are asking for not correct. So how many of them are not correct here? 1, 2 and 3 only. All of them are not correct. It means wrong answers hai usme. Okay. Then next question. Consider the following statements about the Lokpal. The power of the Lokpal applies to public servants of India, but not to the Indian public servants posted outside India. So Lokpal kab aaye? Therefore, they have been brought in under the Lokpal and the Lok Ayuktas Act 2013. These guys have come after this 2013 Act. You guys might have heard about the Anna Hazare, Chalavali. So Anna Hazare and all the other people who became the Chief Minister of Delhi. So they all sat on a dharna saying that हमें लोकपाल चाहिए. So they brought in the Lokpal. So Lokpal and the Lokayuktas Act 2013 was brought in the parliament. Based on that, Lokpal was brought in. Now here the question is about the jurisdiction of the Lokpal. The power of the Lokpal applies to public servants, all of them, group A, B, C, D, yes. Ministers, yes. Prime Minister, yes. Lokpal, the power of the Lokpal applies to public servants of India, but not to Indian public servants posted outside India. That means your IFS and your army people, etc. उसके ऊपर नहीं है क्या? If you are a group A officer, IFS officer posted outside India, can you get involved in corruption? And the Lokpal cannot actually, inquire you. ऐसे तो नहीं हो सकता ना? So it's a common sense question. So public servants posted outside India, they cannot, but not to India, no. Statement wrong, galat hai. Chairperson or member shall not be a member of the parliament, yes, or a member of the legislature of any state, yes. If you want to become say a Lokpal or a Lokpal's member, then you cannot be MP, you cannot be MLA, that's correct. And only the Chief Justice of India, whether incumbent or retired, has to be its chairperson. Again, we have one more term here, only. Only ke bare mein, again, there are a lot of trust issues that we have. Only, no one, none of them, all of them, isko trust nahi kar sakte. We have trust issues with these guys. So only the Chief Justice of India, whether incumbent or retired, has to be its chairperson. So is it correct? No. It can be the CJI of India. It can be a Supreme Court judge or any eminent person can be appointed as the Lokpal. It need not be only the Chief Justice of India. अगर सिर्फ चीफ जस्टिस और रिटायर्ड को रख देंगे, so we have very small pool of people. What if any of the chief justices do not agree to be Lokpal? So we can't do anything, right? So इतना small pool तो नहीं रख सकते, practically not possible है. So statement 2 will also go wrong. Statement 3 के बारे में देखते हैं. Chairperson or a member shall not be a person of less than 45 years of age on the date of assuming office as the chairperson or member. अगर आपको chairperson या member बनना है तो आपको उम्र 45 के ऊपर होनी चाहिए. So is it correct? Yes. That is there in the Lokpal and the Lokayukta Act itself. Lokpal cannot inquire into allegations of corruption against the sitting Prime Minister of India. अगर आप भारत का प्रधानमंत्री हैं, so Lokpal, can he inquire against you or not inquire against you? You are also an MP, you are also a minister, you are also holding an executive post, you are also liable for corruption. So अगर inquiry करते हैं, नहीं करते हैं, करते हैं. But since he is the Prime Minister, there are certain safeguards that have been given. So inquiry करने का है तो कर सकते हैं. So most of them, 6 out of 9, there are 9 members in the Lokpal, 8 plus 1. So out of 9, 6 persons have to agree. 2/3 has to agree. Then only then you can institute an inquiry, or else you cannot institute an inquiry. Certain safeguards have been provided. अगर inquiry कर सकते नहीं कर सकते, कर सकते. So cannot inquire, no. This is a wrong statement. So 1 is wrong, 2 is wrong, 4 is wrong, 3 is correct. They are asking which of the above are correct. So which of the above are correct? Third one is correct. Is there an option here? हाँ, यहाँ पे है. ये 3(1)B. This is how you start decoding the question papers. You need to look at them very clearly, because there are certain patterns, certain questions which get repeated, certain ideas, certain areas, and generally if you look at the last say 5 to 6 question papers, you will get a fair idea about which topics are getting repeated. Are you able to understand this? Yes. So let us take a break now, small break, and let us continue with the UPSC 2024 question paper. I hope all of you have liked the UPSC 2025 question paper, which has been very easy. In terms of polity, others के बारे में मैं comment नहीं कर सकता. So polity, it has been definitely easier side only. Okay, fine.